Good afternoon, everybody. Hi. For those of you who don't know me, my name is Deborah Oppenheimer, and we're going to try and talk about animals and their issues. You should all see up on your screen my PowerPoint presentation in the center of the screen. That thankfully should take up most of the screen. There should also be a very small box at the bottom right-hand side of the screen with the video feed of me. On the left side of your menu, please feel free to select the questions and answers icon and type out all your questions, and I'll try and address them at the end of the webinar. CMCA credits are automatically generated once the webinar hosting site provides us an attendance confirmation report, and those credits will be sent via email within about 48 hours after the webinar. The credits aren't transferable. If you have any questions or concerns, please email Summer Sims at ssims@altitude.law or call 303-991-2076 if you have any questions about your CMCA certificate. All right, and with that, we're going to talk about animals and all the different animals that pop up and cause you, the managers or board members, headaches. And there are lots of them. As usual, if you have any questions, please always check our website. We try and keep all kinds of things going on there. Right now, you should be seeing, if you are on our newsletter or blog, lots of blogs about all the different bills that are heading through the Colorado legislature, because there's a lot that have been dropped and we've been watching them and trying to keep you guys up to speed on what's going on. So if you have any questions, check our website or sign up for our blog or newsletter. So pet issues. There are tons of them, okay? And those pets are, there's pets, right? There's pests, which are some internal, some external. You might all be thinking to yourself, Deb, why did you put chickens as a pet? And I'll tell you why when we get there. Obviously, the size, the weights, the waste elimination, some of them are dangerous. Some communities don't allow any. And at the very end, we're going to get into some FHA ADA issues that have to do with animals and pets. When we get there, I know there'll be lots of questions, and understand we're going to skim it because FHA could take hours. And in fact, we do an entire class just on FHA. So when you think about you're going to do regulations, let's start with dealing with pests. And what do I mean by pests? I'm talking ants, I'm talking cockroaches, I'm talking bed bugs, pests, okay? When we think about can the HOA, should the HOA do something because you got a call, oh my God, there's bed bugs in our unit. First things first, you need to look at what are your obligations. And it may be you have none, right? It may be there aren't any obligations for the HOA, and your answer is for the manager, thank God, not my problem. And that may be the answer. But it always depends on what it is, what the pest is, where the pest is. Was there any connection to conduct of the resident to the pest, right? Because when you're looking at pests, sometimes the issue is something that the homeowner did, right? The homeowner may have been doing something that caused the pest to arrive, but some pests, there's no connection, right? So we're going to kind of talk about the difference, right? And I already see people asking questions about FHA, and that's at the end of the show. So we're going to hold that until we get there. All right, so let's continue on with pests. Internal, as I said, bed bugs, mice, rats, ants, cockroaches. A lot of that is going to determine where are they, right? If you have mice that are inside somebody's unit, that might not be the HOA's problem. But what if the mice are down in the crawl space, and the crawl space is a common element? Now it is your problem. So the first thing when you start talking about pests is we want to know where it is, right? The other thing is we want to know how it got there, right? So externally, you could have raccoons, you could have squirrels, you could have rabbits. We've seen bats, we've seen bees. All of those things show up, and when they show up, the managers get the call of, oh my God, are you going to fix this? And the first thing you have to look at is how did they get there, right? One thing you always need to keep in mind when you're looking at these is Bed bugs don't necessarily have anything to do with cleanliness. So you can't start presuming or accusing a tenant or an owner that they caused the bed bugs. They get brought back on suitcases, they get brought back in all kinds of different ways, and there's really a lot of times no connection to conduct of the owner or tenant, and therefore no responsibility of them. At the same time, if it's internal to the unit, it may be no responsibility of you, the landlord. You might be the landlord's issue, right? Owner has to talk to the tenant and discuss with them how they're going to clean it or what they're going to do. But it may have no issue with the manager. Now, obviously, what you always want to be concerned about when you have a call about bed bugs is, are they going to get in the walls, which is probably going to be a common element if it's a condo, and therefore it's now going to be the HOA issue. And is it going to start spreading? You want to look to, sometimes your documents are so old they don't even talk about it. And that becomes very difficult. And sometimes you have to reach out to counsel and say, you know, what can we do? How can we help? Should we just say it's not our problem and put all the neighbors in touch with the, you know, here's some handymen, here's some pest control people, different people that they can call. And it might be a list you provide to them, but you're not doing anything other than providing that list. Sometimes, you know, the issue is whether or not it's in an area that is yours, right? Is it in the crawl space? Is it in the attic? Both of those are areas that are frequently common elements. And if they are a common element, then the HOA is going to have some responsibility to the cleaning it, fixing it. Obviously, as I also said, it depends how they got there, right? Do you have, I mean, bats generally get into the attic because there's a hole in the soffit, or there's a hole in the siding, or there's something that needs to be maintained. Well, if it's a condo, that hole is the HOA's responsibility to maintain. So if they're up there in the attic, there's a pretty good chance that the HOA is going to have to take some steps, and you're going to look at your documents. Because what you want to see is do your document say the HOA shall maintain that common area? And if it's a shall, then once it's been reported to you, you have a duty to go up there and get them out. That means hiring some responsible companies to come remove the bats out of your attic, or to trap the squirrels that might have gotten into your attic. Obviously, it also depends on how did they get there, if there was any conduct of an owner. Oftentimes, we might have rabbits. We might have owners that are feeding the rabbits because they're cute, or maybe they're got some squirrel feeders out there or something that are encouraging the animals, and now they're in your attic. And if that's the case, you want to go back to that homeowner and demand they stop the conduct. And if they don't stop the conduct, then they may be responsible for the cost. But you're going to have to look to your declarations to make sure that you can transfer that cost over to the homeowner. And you're going to have to verify that there's conduct on the part of the homeowner that caused that. You know, many times we will see issues where someone calls and says there's cockroaches, and, you know, your HOA has to do something. Well, those come about by cleanliness issues, right? And so oftentimes, if your documents require homeowners or unit residents to maintain their units in a sanitary fashion, and you're going to have to look for that kind of language in your declaration. If you can find the language in the declaration that has that obligation of how they maintain their unit, now you've got a covenant violation. Once you have that covenant violation, then you have the ability generally to move some of those costs back to the owner that caused the problem. If you don't have any obligations like that, you don't have any ability to just assign a cost to a unit owner. Now, if you are a community that is post-Kiowa, you may have an ability to say the only units that are going to be benefited by the cleanup and the treatment of the cockroaches are these units, and it's the units that are dirty and not being maintained, and therefore the cost goes just to them. But again, that's going to depend on your documents and whether you're pre-Kiowa or post-Kiowa on whether or not you can go in there and clean up and then bill it back. Nuisance may be your only avenue in some of these situations, right? Because some of these situations you're looking at such old documents that you're having a hard time trying to figure out whether or not that, you know, do you have any ability to take action? Step one. And if you take action, do you have any ability to charge it back? Step 2. And that's going to be declarant or declaration dependent. You're going to have to look to the declaration. You're going to have to verify that there's something in there that gives you that authority to take action. And sometimes it's going to be a covenant violation you've got to show. And you may be stuck with just nuisance. But again, you're going to have to look to your declaration to see what you've got. Obviously, cleaning is one of those things that we look at a lot of times when these things happen. Feeding animals becomes a big issue. I've seen a lot of communities that have problems with rabbits, and the rabbits burrow under the patios, and then the patios crack because there's a hole right under the middle because the rabbits are burrowing. And so again, you're going to have to look to, can you see who's feeding the animals, who's keeping them there? And the other problem is sometimes look to city ordinances. They can also help, because a lot of the communities that are up near the mountains, right, or that border areas that might have a lot of wildlife, have put into place ordinances prohibiting feeding the wildlife. And that might help you out, because then you can turn it over to somebody else who's going to come in and enforce it and stop it and issue them violations of code, right? So it's always great when you can look to, an outside agency, code enforcement, and say, hey, come make these people stop feeding the animals, because they're feeding the rabbits, but that's drawing in the foxes, and it's drawing in some communities, mountain lions, or they're putting out food and it's drawing in bears. All of those things are something that you might want to be able to turn over to a city, and then they're going to step in and fix it. A lot of times we see rabbit or squirrel feeders, and also bird feeders that bring in mice, right? Bring in rats. Because if you have ever had a bird feeder of any kind, underneath it is all the droppings, because they're not really neat about picking out what they want, and they may be picking out only certain things and scratching the rest off, and it's dropping on the ground. Or the squirrel's picking out what he wants out of the bird feeder, and the rest is dropping on the ground and causing problems. So sometimes you may have to implement a rule to stop the bird feeders. And what you want to do is you get a lot of pushback when you do those, and so you want to make sure that you can show owners why you're doing it and why it's appropriate, if your documents don't give you that helpful habit. Cleaning habits not only cause issues with things like mice, rodents, cockroaches, hoarding also causes those same problems. And so if you have shared walls, again, the failure to clean, or the fact that they're packing so much in there that they couldn't possibly clean, can cause problems. And so a lot of this stuff can escalate. And so you have to start at your documents, to your declaration, see if there's some language in there. If you can't find any language, call the attorney, see if there's an ability to draft some rules to help you put some restrictions in there to stop some of this conduct that's bringing in all the animals. Because some of those animals are ones that none of us want to have show up, much less on a Ring camera saying, hello, here I am, and welcome to the community. And we have seen a lot of these predators. We've also seen coyotes and foxes show up, and kind of that depends on, do you have a lot of rabbits? Because you got homeowners feeding rabbits, and so they're a food source, unfortunately. And so when those start gathering, you get some other people there as well, and you really don't want that to happen, right? What do we do when the owner does not cause the problem? Well, this is the one thing that often happens, that you have to explain to the board that, what, if the wasps, the bees, the bats in the attic, the rabbits under the deck, a skunk under the deck, the squirrels, a lot of this are naturally occurring, right? Colorado has a fair amount of wildlife. If your community backs up to any kind of open space, if you back up near any trails or rivers, you're going to have some animals come around, and that's not anything that you can pin on an owner. And so if you end up with wasps in your attic or bees in your attic, the attic is the HOA's common element. HOA just is going to have to hire somebody to have them removed. Again, that's not something that you can put back onto an owner. They didn't show up because of failure to clean. They didn't show up because of anything else. Now, obviously, if you have an owner that decided to be a handyman and do some work in the attic on his own, and he caused holes, and those holes is what allowed the wasps or the bees or the bats in, then you can look back to the owner to recoup some of the damages that were created and the costs that you had to do for the cleanup. And so you want to take a look at that. one of the things you do want to remember right now is we have a shortage of bees, and that sounds really weird, but that's a real health hazard because bees are what gets us all of our food because they pollinate things. And so there are all kinds of organizations that if you have a bee, you find a honeycomb somewhere it shouldn't be, and you have a whole bunch of bees, you can actually call these people. There's a couple different organizations. You can type it up into Google, and there's organizations, they'll come get the bees for you, right? You don't have to pay to have them removed because there's something everybody needs and wants right now. And they'll come take them and remove them and get them away from you. So if it's bees, that's one that might be a free thing to the HOA because we have a shortage and people need them, and so they're removing them. Obviously, you're going to have to pay to remove the wasp nest or deal with the bats or the rabbits. And again, if they're in the crawl space, they're in an attic, and it's your common element, there's a good likelihood that you are going to be the one who's responsible to have them removed at the association's cost. Questions, a couple of them. Can we do anything about pigeons perching on a condo roof? Well, I mean, the pigeons are something that, again, it's not like they're called to a community. Now, obviously, if you had a resident move the pigeons in, right, because he wanted to have pigeons, you could go after the resident and say, hey, you brought them here, you have to pay to clean it up. But if they are just naturally occurring and they showed up, then you're going to have to handle either paying to put like the spikes on the roof. Other things you can put on a roof are like tacky, sticky stuff. They don't like to touch that, evidently. And so you see those as an option to put on your roof. You have to be careful when you start talking about removing animals. One of the things that a lot of people are unfamiliar with are there are laws out there if the animal is a migratory bird, right? You can't just kill it. So there are some woodpeckers that are migratory. And so if they do damage to your wood soffits or your wood eaves, you have to go get a special permit, and you have to work with professionals to show that the only way to get rid of them from your home or your community is to kill them or trap them or something. But it's illegal to just kill them. So you can't just, go out there and you got a board member who's a crack shot and he just wants to go out there and take care of it. That's going to get you in a lot of trouble if it's a migratory bird. So do be aware that there are laws out there. You can't just take care of that. Termites are something, again, those aren't caused by an owner. And so unless the owner, up in the mountains, right, we have a lot of communities that have wood fireplaces and people bring in wood to burn. And if they stack that wood up against the building, sometimes you can get termites in the building because of the homeowner stacking their wood, their fire source next to the building. If you get that, you might have an ability to charge back against the homeowner if they're the one who stacked that wood there or their tenant. Okay, but otherwise termites are going to be one of those things you're just going to have to pay for. Again, rats and raccoons, if they're outside in the common area, they're going to be an HOA that's going to have to deal with it because that's not an owner responsibility. One of the things you want to be aware of is we've had several communities in Aurora where they had tenants who were refusing to put the trash properly away, and the city came in and code enforcement started citing the HOA because who's responsible for the trash? That was the HOA. The HOA arranged for pickup. And even though it wasn't the HOA leaving the trash around, the HOA got dragged into court and was about to be fined because they weren't keeping it clean enough and they had a rat infestation. And they had to spend a whole bunch of money building bigger enclosures, better enclosures, getting better trash cans to keep the lids on to reduce the rat population. And again, that bill came to the HOA, not the individual owners. And even in that case, it was the individual tenants who were just throwing their trash close to the trash can without getting it in the trash can that was causing the rats. The problem with that is which person threw the hamburger bag there? Which person, threw what kind of trash there? And unless you catch them in the act, you can't charge it back. So that becomes a problem. Common areas, again, the association generally has primary responsibility for the common areas, and you have that association obligation to maintain it. So when you're looking at different issues, if you've got, one of the questions is, what about geese? Well, if your geese are running around geese are migratory, so you're going to have to be careful about how you remove them. And you want to look into specialists who actually know the law on what you can do, what you can't do, what you're allowed to do, so that you don't run afoul of any of the laws against affecting migratory animals. So you want to be very careful about that. Can you take down a nest once established but unoccupied? As it's been explained to me in the laws that I have seen, the law is preventing you from killing the animal. So removing the nest would not be something that would violate the law. Do I know if swallows are migratory? I do not. I don't think they are, but I do not know that for certain. And it's something you want to double check because, again, you don't want to run afoul of the migratory bird statutes and get yourself in trouble. And there are all kinds of specialists in this. I mean, there are specialists who have dogs that are their entire job is to chase the geese. And they annoy the geese, and the geese fly away because they don't like the dog running around. And again, you didn't kill them, and so it's allowed. Again, when someone contacts you, what your first step is going to be is let them know that, one, I'm going to look at the documents. I'm going to see whose responsibility it is. And if, in fact, it's not your responsibility, you're going to have to try and educate and explain to your homeowner or your resident, whoever's calling you saying, hey, come fix this. That's not your job. That's one of the biggest things that you're going to have to do, and you're going to have to be able to explain to them, you might have spiders in your house. That's a pest. That's not my problem, right? That's the tenant's problem. Go get go to the store and get some Raid and take care of your spiders. That's not my job. That's not my responsibility. But when it's down in your common elements, it might be. So step one, always look to your declaration and see what area, where's whatever is bugging them. Is it yours? Is it theirs? Did they do anything to that common area that caused this problem? If not, it's probably going to be the HOA that has to hire the professional and exterminator and get rid of the problem. So let's move on to pets, right? To animals. Understand that there are many, many people, and I'm probably one of them, who have pets that are their kids, right? They're furry little kids. And you always have to remember when you start making demands as a board, start making demands as manager on behalf of your board, you're asking them to do something with their children. And so understand the response that you're going to get is going to be pretty strong regarding. So you have to be aware of that. At the same time, there are many people who don't like pets, or maybe they have medical issues and they can't be near them even if they did like them. And you always have noise issues from the barking dog. You have the waste issues, the health hazards from dog waste. They're pretty nasty. Realistically, that's always a huge frustration. And even when owners pick up after their animals, dogs damage things. If they go to the restroom in the same spot every day, day after day, day after day, you're going to have a dead piece of grass, and that's damage to the community that the HOA has to deal with. Can you have a camera on areas to catch who is causing issues? Yes, you can. But again, whenever you put a camera up, you want to be aware of the fact that you are need to put notices up. You need to put some signs up telling people that they're not monitored and that they're kept to determine damage. So, yes, you can generally have cameras on a common area watching common areas. So when we're looking at chickens, why did I put chickens under pets? Because there's a Colorado Supreme Court case that said chickens may be pets, and it's a case-by-case analysis, and the court cannot presume that they're not pets until they investigate. So the Colorado Supreme Court didn't say chickens are pets, but they said they may be in certain circumstance. In that specific case, it went to the Colorado Supreme Court. The Colorado Supreme Court said the 23 ducks and various poultry did not appear to be pets, but they could be, and the court sent it back down to get more facts about the circumstance. So when you're looking at chickens, be aware that you have to start with your declaration. Does your declaration say no poultry? What it many times says is no livestock, no poultry, only pets are allowed. Well, okay, if I think my chickens are pets, then they might be allowed. Many of you might know Von Miller, when he was a Bronco, had chickens and he named them after teammates and he considered them his pets. So you got to think about the fact of chickens aren't automatically out. You also have homeowners who don't understand that there are county rules that allow for chickens, and so they presume those county rules trump your covenants, and you have to educate them that the way the wording is in most of the county restrictions or city restrictions that allow for chickens, they do not trump the covenants, and most of those county code provisions on chickens simply state that residents within the county may have chickens. That's fine. That means it's not a violation against the county. It's still a violation of the covenants if your covenants prohibit it. So you need to be able to work with your homeowners, your tenants, and explain to them what's going on. When you start looking at dog and cat restrictions, many condos put size and weight restrictions in there. And that's fair because if you're a condo and you have maybe, a 2 foot by 2 foot piece of grass on each side of the sidewalk as you walk out the front door, you don't really have a lot of area for dogs to, go to the bathroom in the mornings. And so reducing size, reducing numbers is an appropriate restriction. And it also is appropriate because, having a Grand Mastiff is a beautiful dog in the sweetest disposition possible, but he could be 150 to 200 pounds and him in an elevator takes up a lot of room. And so him coming in and out of his residence is difficult. And so you can support and explain to a court size and weight restrictions in a condo based upon, grass, square footage, space in the building, space in the hallways. When you are a single family community, you almost, you're going to run afoul pretty quickly of a court saying it's none of your business what type of animal, what size the animal is. Now, most courts will still uphold a restriction on how many dogs can be at a residence, even a single family residence, because most counties have them. Most counties have restrictions on no more than 4 dogs. Most, you have to check. In Colorado, that's a very common restriction to find a prohibition of more than 4 dogs at a house. Why? Because then they start barking and you get pack mentality. And so it's very common to see a restriction on the number of animals, even in a single family property. It's something you want to be really careful about when you start talking about a dangerous dog. And why do I say careful? You want to define it. You don't want to say pit bulls are not allowed, period, because they're dangerous. And that's not really true. Pit bulls can be very gentle. Pit bulls can be very mean. You want to lay out in your rules that any dog that is aggressive will be deemed a dangerous dog and not allowed. You want to make your rule go to behavior, not to breed, because it's a much stronger rule in a courtroom. And you're going to have much less likelihood of them attacking a breed restriction versus a dangerous dog description. Now, sometimes, and this goes for condos and townhomes, if the HOA is the group getting the insurance, you might have a restriction in your covenants that say no resident can do anything that will increase insurance or make it so we cannot get insurance. And some insurance companies don't like pit bulls and don't like Rottweilers. And if that's the case, then it's okay to have a rule not allowing them because you can't get insurance with them in the condo or in the townhome. But you have to look to your insurance and you have to look to what your declaration says. Those have been, they're hit or miss. It's kind of, sometimes there's no pit bulls and sometimes they're fine. And so that's something you can look at. No barking, howling, obviously that's a clear enforceable rule. It's a nuisance. Keeping them on leash, that's also something that's always allowed and upheld. Having specific pet areas, that's always allowed and upheld. Obviously we always have problems with cleanup because we don't know which dog, somebody didn't clean up after. And so then the question is, how do you figure that out? Well, you can go with doggy DNA. It's an annoying thing, but it's something that we've seen and some communities prefer to do it that way. But that means somebody's going to go out there with a little spoon and send it off to be tested. And it also requires registration up front. So, that's one option. Putting cameras up, that's another option, but that means somebody has to then watch the camera. And once you figure out which person, is on camera and just letting their dog take a dump and walking away, do you know that person? Can you recognize that person? And which unit does he go to? So it always becomes a problem kind of identifying who didn't do it. Damages, the same thing. If you have damages due to pets, most of your documents and declarations are going to allow you to try and recoup it if you can identify which dog did the damage. And that always becomes the problem. Can you have a restriction that says absolutely no pets? You can in the covenants. I wouldn't recommend that in a rule, but I think in the covenants, you could do that very easily. Breed restrictions often are not upheld. Somebody asked a question, how are breed restrictions upheld? And they're often not. You have to be able to establish why you're doing it. Understand, when you're talking a rule, rules have to show that they're reasonable. And there's a valid reason for having the rule. And so just having a flat out breed restriction isn't often something that you can support in a courtroom. What if an owner wants to foster a dog or dog sit for a dog when they already have the limited number of dogs? Again, I mean, that depends on how the rule is written. If your document says no more than 4 animals in the house, no more than 4 is no more than 4. And while they have it, they're in violation. Obviously, when we look at HB 1137, they're going to have that dog for longer than 30 days, or you're not going to be able to find them on it. We'll come to that in a minute. Can declarations be written to make animal control responsible for dangerous dogs? Yes, your declaration can actually say that you will not handle dog situations, and that any issue of dogs has to be dealt with by someone else, and that the HOA is not going to handle it. You're going to have to pull out any restrictions or discussions on animals and actually put verbiage in your declaration to write that the HOA won't be part of that problem. That'll be a code issue or an animal control issue. And I've had communities who've done that. Can an HOA allow for pets for owners only, but not for renters or tenants? So not in Colorado, but in a state that also has the Uniform Common Interest Acts, just like us, has Kiowa, but they've adopted that because that's out of a uniform set of laws. And there is some case law, it's actually out of New Jersey, that came out and was very clear that says you cannot have different classes of citizens. And so if you allow tenants to do one thing and owners to do another, you are creating different classes of citizens. And when you do that, it could be challenged. Hasn't happened in Colorado yet, but our state looks to other states, and so frequently it's something that comes up. And so it would be something you would want to be concerned with. So what are the rules? Can you create rules on these topics? Yes, most of you are going to be able to create rules on these topics because Kiowa allows you to create rules whether you are pre or post Kiowa. If you are a non-Kiowa community, you're exempt, or you have voluntary assessments, then you're going to have authority in your declaration to adopt any kind of rules against pets. Okay. So those are the two main ways that you're going to be able to adopt rules. Obviously, none of your rules can conflict with the deck, and you cannot create new use restrictions, meaning you could not put in your rules, no animals will be allowed if your declaration talks about animals, unless your declaration says the board can decide not to allow animals, and then you could create a rule that said no animals. But you don't want to try and by rule prohibit pets and animals inside a unit. Anytime you're talking inside a unit, generally you want it to be in the declaration. It's not something you want to do by rule. And again, as I already kind of talked about, your rules have to be reasonable. So you can't just set forth something without any connection to your area or why you're going to do what you want to do. And obviously you can't conflict with state and federal laws. And a lot of these things are going to come up when we start talking about ESAs and FHA. Can we have a rule for owners to have pet agreements as part of their lease when renting? You can. It would be really difficult to enforce, but you could certainly do that. I mean, again, that's something that dependent on, you generally don't go into the terms of what's in most agreements to lease, except that the lease will make the residents comply with all the rules of the homeowners association. Other than that, the courts would frown on you trying to determine what the leasing rules are. Commercial office building, have owners only bring their dogs to work, no tenants, and have a written policy. Again, in Colorado, we haven't had that law come up, but if Colorado follows suit to what other courts have done, treating owners and tenants differently is generally not something that the courts will support. And are pets a protected class? Only in the terms of if they are they're going to fall under FHA probably. All right, so when a court reviews the rules, what's it do? First, it's going to say, did you have authority to adopt them? And it's going to look to, are you a Kiowa community, or is there authority in your declaration to adopt these? Do the rules contradict any other law or contradict the DEC? Does it further the purpose of the association, right? Like I said, when we were talking about putting caps on how many animals you can have in a condo, limiting how many cats are on the fourth floor bouncing around and driving the people on the third floor insane because they're bouncing around chasing each other, absolutely furthers the purpose of the community. You always want to connect why you're doing what you're doing and be able to show the court, this is how this affects the rest of the building. This is how this affects the community as a whole. This is why it's important for the HOA to get involved at this level. Is the rule clear? Don't say, well, they can take reasonable steps to keep their dog, happy. Okay, what's a reasonable step? Spell out what you want. Must pick up after the pet. Must keep the pet on a leash. Can only have 2. Make your rules clear. And is it reasonable? Why did you have that rule? Why does it make a difference between a tenant having a pet versus an owner having a pet? We can all generically say that we believe owners like the property better than tenants, but can you prove that? Because that's what it's going to come down to in a courtroom. And can you fairly enforce it? So you always want to make sure that that's something you can, you don't want to have a rule against something that you can't enforce, like a 2-hour parking rule. Are you going to go out there every day and mark tires to make sure that the car's only been there 2 hours? Because if you're not fairly enforcing the rule. Can you prohibit animals? Again, unless the declaration says the board may adopt pet rules and may by rule decide pets are not allowed. Unless your declaration says that, you cannot prohibit animals by rule. It needs to be in the declaration. Can you place restrictions on where they go to the restroom? Yeah. I'm not sure it's really enforceable. My dog tells me I'm going now, and he goes. Now, so unless I want to pick him up to make sure he doesn't go before I'm ready to get him to go, he goes when he's going to go. So yeah, you can try and have a rule of where they can take their dogs, and you can encourage it by having a place where there are pet bags for the dogs, because that helps reinforce to the owner, here's where we want you to go, and plus we're helping with the pet bags. Can you require leash by rule? Absolutely. Can you require waste pickup by rule? Absolutely. You can't really limit, as I said, where they stop to poop or pee. And can you limit FHA and ADA animals? Yes, to some extent. So let's go back and say, can you restrict an FHA ADA animal to be on the leash? Yes, unless their owner cannot physically hold the leash due to the disability. Can you require waste pickup of an FHA ADA animal? Absolutely. If they personally cannot pick it up, they need to make arrangements for someone else to pick it up. So yes, you can have rules. What if somebody says it's an ESA dog and it barks and howls nonstop? Fine them. They're not immune from the rules. And if their dog is still barking and violating and howling, fine them for that. And they are responsible to pay those fines. Okay. Every association I've managed has a rule stating that only owners can have pets. Okay, again, it's challengeable in court, because if the court decides that you're creating two different classes, they may not let you continue with that rule. Okay, we'll get to emotional support animals. Can you ban pets in the community park due to pet waste issues? If you own the park, the HOA owns the park, you can certainly put up signs, no pets allowed. I don't know how you're going to enforce it. That's going to be the difficult part, because people tend to ignore things like that when they wish to. How do you enforce dogs not barking if the violation is technically resolved when we go on site? Well, I mean, that becomes a problem with HB 1137, right? The dog's barking. HB 1137 says you have to give 30 days to correct the violation. So if the dog stops barking one day within the 30-day window, you don't ever get to fine. So it's going to be almost unenforceable unless they do some cleanup on that bill. So, as I said, one of the worst problems you're always going to have is trying to remember or trying to prove whose dog it was, left the pace, and didn't pick up after it. And especially if you're anywhere near a walking trail or a river, people walk along it, and you're never going to be able to prove whose dog did it unless you have cameras or you do DNA doggy sampling. But again, you're going to have outsiders from outside the community who might leave the mess, and you're still going to have a problem. Dog waste is always an issue, because you're always going to have those homeowners who are going to be absolutely great about it and pick up after their own dog, and you're always going to have those who are going to ignore it. And trying to catch the ones who ignore it is always difficult. And so unless you have cameras or DNA, it becomes very difficult to find them and make them responsible for it. In Colorado, there is a statute on dangerous dogs, just so you know. And one of the things that I hear on a frequent basis is a dog bite happened in your community, and animal control was called, and they didn't take the dog. And that happens frequently. They will not remove the dog if the dog bit another dog. They will quarantine the dog if it bit a person sometimes. And sometimes the owners persuade the animal control to let the owner quarantine the dog in its own property. I haven't seen a consistent approach on how dangerous dogs are handled statewide. It's across the board what the animal control officers do with it. And I don't think that's ever going to change. So if you have issues in your community, you have lots of dogs in your community, you certainly want to think about having some prohibitions of your own in your documents to prohibit the dangerous dog, because the state law really isn't going to consistently remove the dog or deal with the dog and get the dog out of your community. But if you have it in your rules, no dangerous dogs, you're going to be able to, one, fall under the HB 1137 3-day rule, because the dog's bit, right? So if there's a dog bite, send that 3-day letter, get that dog out of our community immediately. And you don't have to deal with whether or not animal control thinks it should be put somewhere else or not. You won't have to deal with it. Again, one of the things you want to be careful with is sometimes you might hear about a dog bite and think, well, I'll let animal control handle that. Be very careful about that, because if you, the HOA, are aware the dog bit somebody and you have a prohibition for dangerous dogs in your documents and you don't take steps to remove that dog and it bites somebody else, they're going to have a claim against you, because you could have done something and you chose not to. So you want to be careful about that. If you put it in your documents, you're going to need to enforce it, right? Don't want to put it in there if you're not going to enforce it. Have I ever experienced a dog removal after a bite when the city animal control? Yes. I mean, I have sued on behalf of HOAs to remove a dog because the dog bit and the city animal did nothing. And so we had HOA covenants, and we said, get the dog out of the community. We have a dangerous dog prohibition, get it out. And so I've filed suit on that multiple times, and the dog's been removed every time. Can the city enforce violations for barking? Well, I mean, yes, the city is not bound by HB 1137. And so if your community is within the city and you've got barking dog restrictions and you're having problems because you got that stupid 30-day restriction for barking dog, tell your homeowners to call the city and make the complaint on animal control to stop the barking. And that way, that is a option that you can use, again, because our hands are going to be tied. I mean, must give 30 days prior to fining. Obviously, if you set it up when you created your covenant enforcement policy to have a warning letter, then absolutely you can utilize a warning letter, and it'll be a shorter period of time to try and get them to take action. But you can't ever get to a fine unless you get out there 30 days. Never going to get there. And if they stop barking one day, they're going to have an objection or have an ability to defeat your fine because their dog stopped. And so unless they amend 1137, you're going to have a hard time trying to do anything with dog barking. Same with dog waste, same with dog leash. 1137 on a lot of these dog issues and dog control issues, you're going to have a horrible time doing. So the commenter who suggested call the city for the barking, call the code enforcement, it's an excellent suggestion because they don't have the 1137 problems that we have. Okay, so there's been a lot of questions I've skipped over because they have to do with this. So let's jump into this. So first and foremost, ADA only applies to places open to the public. Most of your HOAs will not have ADA issues, right? Most of your homeowner associations are open to members and their guests. They're not open to the public, so ADA does not apply, okay? So we're going to deal with FHA rules because FHA does apply to homes. It does not matter with you're not the person selling. FHA is going to come into play for HOAs. Okay. Service animal versus ESA. Huge difference. A service animal has been trained to do a task. An ESA is not trained, and it simply comforts a person who has a disability. Okay. The courts have been absolutely clear. No training whatsoever is required to an emotional support animal. Training must happen for a service animal. Okay. Trust me, if you guys have service animals in your community, you won't care because they are the best trained animal you've ever met. ESAs are absolutely ridiculous because there's no training. There's no requirements on what type of animal. There's nothing. And they're generally the ones that are causing the problems because they're a ESA and they're barking all day because they're left home alone. What happens when we have the ESA request? Step one, what happens? Well, when you get the request for an ESA or a service animal, any dog, and you've been requested to allow the dog, step one is not on the screen. Step one is, do you have any prohibition against the dog to begin with, right? If your community allows for 2 animals and somebody comes to you and says, no, I need 3 because I need this animal. This is my emotional support animal. Go, great. You can have this animal that's your emotional support animal and one of the other 2 has to go because you only get 2. Okay. But remember, one of the games that is played in this respect is if your rules say no more than 2 pets, the ESA owner is going to walk up and go, my animal, my emotional support animal is not a pet. And the courts have already said that. So I don't fall within your 2 pet restrictions because it's not a pet. Okay. So when you're drafting rules, you always want to say no more than 2 animals. And an emotional support animal is still an animal. So you can have your emotional support animal and 1 other animal. There you go. You don't need an accommodation, but you can't have 3. Okay. Now, second thing, let's assume that you're a community that has no pets allowed. And a person walks up to you and says, I want to have a dog as an emotional support animal. Okay. Step one, what do you do? Well, first, are they disabled? If they're not visibly disabled, you can't see a disability, right? Then they don't get to have the animal, right? But if they are disabled, then you have to make a reasonable accommodation to allow them to use and enjoy their house, okay? Courts have said it's a reasonable accommodation if what they've asked for doesn't result in an undue financial or administrative burden or fundamentally alter the nature of the housing, okay? So when we're talking dogs, the courts have said it's a reasonable accommodation to let them have the dog. So how do we know if they're disabled? Well, this is the definition of disabled. It's a physical or mental impairment which substantially limits one or more major life activities, or a record of having such an impairment or being regarded as having such an impairment, okay? If you can't visually see they're disabled, you can ask the following things. You can ask them to provide for you sufficient reliable information that allows the association to verify that what their problem is meets the HOA or the Fair Housing Act's definition of being disabled. Let me give you an example. If a homeowner come up and said I had knee replacement surgery and I am going to need a dog to help me walk until my knee heals. Well, step one, is he disabled? He's not. Fair Housing Act says a disability is a permanent condition. Is he having problems walking? Absolutely. But under the Fair Housing Act's definition, he's not disabled, right? So one of the things that often happens is people give you a letter from a doctor saying, I know he meets the FHA definition. Well, really? Are you a lawyer? I know you're a doctor. Why don't you tell me what his medical condition is? And let me decide if he meets the definition that's in the law, okay? Because the law, the doctor probably would tell you he is disabled for the next 6 months because he can't walk. But because it's temporary, it doesn't meet the legal definition, okay? A description of the accommodation that the resident is requesting. How does having a dog help somebody who can't hardly walk? Probably not, right? There's no connection, right? And that's the third thing. What's the relationship between the disability and what they want? You know, it's one thing to say, I need a ramp because my mother needs a walker and I need a ramp to her front door. Clear connection between the disability, she needs a walker to walk, and a ramp because she can't do stairs, right? Clear. But, you know, mom's got a walker and she needs a chihuahua. What's the connection? The chihuahua does not help her walk. In fact, it probably trips her. So there's got to be a connection between the request and what the disability is, and one has to help the other. Okay, so, you know, what's reliable documentation? Reliable documentation can be a determination from a government agency, right? It can be a receipt of disability benefits. It can be a note from a healthcare professional. What we have seen that generally is not considered reliable are those online forms that have been coming out and were coming out for years. And those were very, very prominent for a very long time. Secretary Carson, when he was head of the departments, came out with a letter saying that those were all questionable and considered suspect, which was very, very helpful to us because it really slowed down the impact of the tons and tons of letters we were receiving that were online, never met anybody, couldn't swear that they were or were not disabled. They just paid their money and so they got a letter. So those letters are deemed unreliable, and that's actually written now into the HUD's housing standards that those are deemed unreliable. You can't impose conditions if in fact they are disabled and need the animal. So if they are disabled and they need the animal, you cannot require them to pay to register their dog in your community. You can still require them to register the dog, but you can't require them to pay to register. They just get to have the dog. If you have doggy DNA, you can make them comply and provide the sample. You just can't make them pay for it. And you may not pay pass on costs of attorney fees to help you evaluate a disability request, okay? So you can't add those costs onto an owner who truly is disabled. Limits on dogs, limits on breeds. When you're talking FHA, FHA doesn't care if it's a pit bull or a chihuahua. FHA says, does the animal help the homeowner in a respect to their disability? So, you know, if it's an ESA, the Chihuahua is great because it's going to sit in their lap and it's going to comfort them and it's going to help them, right? If it's a pit bull, it may still climb in their lap and comfort them. And you don't get to prohibit it just because it's a pit bull. Now, if in fact the pit bull poses a direct threat of safety to the others and you can document it, and that means you saw it growling, you saw it charge, you saw it bare its teeth and lunge, you saw an aggressive act that is a dangerous act by a dog, you can kick it out. You cannot kick it out simply because it's a pit bull. Okay, so you have to be able to show it was a dangerous dog. Can you get rid of a dog? Absolutely. If you have an FHA approved dog, it can be a service animal, and it bites somebody, it's gone. You are not required to keep that animal in your community if it's dangerous, even if it's FHA. What about violations? Fine them. Off leash, fine them so long as it's not the disability prohibiting them holding the leash, right? If the disability is blindness, they can still hold the leash, and of course they will be holding the leash because that's a blind dog, you know, that's leading them. But you can still make them comply. Not picking up waste. If they're unable to pick up the waste, they have to hire somebody to pick up the waste. They don't get an out, and you don't become financially responsible to pay for it. They remain financially responsible to pay to pick up the waste for their dog. Can you ever make them remove a service animal or an ESA? Well, you can always make them remove either one if there's a dog bite. Beyond that, it takes a huge history to remove those dogs, right? So if you have repeated violations of barking, howling, whining, off leash kinds of things from the ESA, you're never going to really have that with the service animal. If it's really a service animal, 90% of the time the service animal is with the person all day, every day anyway. It's never apart. Those animals are so wonderfully trained. You're not going to see the problem with the service animals. What you're going to see is a problem with an ESA most of the time. That's mostly what you're going to see. And if you have somebody who brought in an ESA and it barks nonstop and it whines nonstop, yes, you can say, look, we're going to fine you, but you've got to have a long history. And if you don't stop this, we are going to demand removal of this dog regardless because you're not complying. But it's going to take numerous violations, and you're going to have to show a history of it to make that happen. What if the HOA allows for two dogs and they want a third? Again, tell them to get rid of one of their other dogs. You cannot have, can you have multiple animals, right, that are service animals? Well, the courts say if each service animal performs a different task, they can have multiple animals. So say you've got somebody with MS and they have balance issues, right? So they have a big dog to help them walk, and then they drop things all the time, and they have another dog that's trained to go pick it up and bring it back to them. They have two valid service dogs. They're each doing a different task for that individual. They get multiple dogs. It's very difficult to prove that you need multiple ESAs because they don't do anything but sit on your lap. And so again, ESA is about emotional, right, service animal. And so again, what you're looking at is completely different, and it's very difficult to establish that in fact you needed multiple service animals. I got lots of questions, and I will try and go through all of them. So I'll go a little beyond the time limit, but we'll try and get through all of them. So if someone has more than one ESA, does each pet need to serve a different type? Yes. And again, as a service animal, it's very difficult to show, since there's no training, why do they need multiple? Because they don't do anything, right? And so that's kind of how we, it's hard to show that you need two service animals. Under what circumstance must an HOA allow a disabled resident to have dogs off leash in a common area? There isn't any. Again, just because they're disabled doesn't mean they get to avoid the rules. They only get to avoid the rules that affect their disability. Remember when I was talking through the question, there's got to be a nexus between the request, what are we requesting happen, and the disability. right? You got a person who has a blood problem and they pass out frequently. They may need a dog near them to come lick them awake, but there's no requirement for them not to carry a leash, right? There's no connection there. Not carrying a leash does not stop them from, having that dog nearby. Now, what if that dog's training is if he passes out, the dog is to run get medicine? Okay, he's allowed to be off leash. You got to connect what the dog is doing to helping the disability. If there's no connection, they can't do it. Okay, they don't get a pass. Would feeding animals apply to cats? Do you have random cats that are out and about, and does your community prohibit cats? If so, then you could have a covenant violation, send a letter for feeding cats.